With the release of ChatGPT and other artificial intelligence applications, there's been a lot of speculation and downright assertions about our future. With over 30 years of experience in information technology, I have more than a passing understanding of AIs, and I've come to the conclusion that much of what I've heard is more science fiction than fact. A recent court case decided in the D.C. District Court revolved around one very important question. Do AIs have rights? So we'll discuss that next at the Constitution Study.
Love the neighbors and have a few good friends. Every day we're everyday Americans. Oh, every day we're everyday Americans.
Hello there, everyday Americans. Paul Engel here with the Constitution Study, where we read and study the Constitution. Teach your rising generation be free. We are returning the Constitution to we the people, and I'm glad you could join me today. I'm going to encourage you to check out more on the website. The Constitution Study website is getting a refresh. You go to constitutionstudy.com, check out all the new features. Hey, maybe check out the Patriots program. The boot camp should be up and running, if not now, very, very shortly. I encourage you to check it out. Maybe sign up for a mailing list or other ways you can be engaged. By the way, if you want to find the links to the quotes I used in this episode, we can find them right there on the website, constitutionstudy.com. Now let's get into this AI confusion. There is a lot of confusion out there about artificial intelligence. Some claim that AIs have the power of independent thought, which will one day allow them to take over the world. Others write off AIs as nothing but a novelty. Now, based on my experience, the truth is somewhere in the middle. Now, I am not an expert on the current state of artificial intelligence, but there are certain things I know to be true. Let's start with what an AI currently is. Today's AI are, in general, sophisticated pattern matching software. What differentiates them from other types of software is their ability to infer a conclusion. For example, if you create a standard pattern matching algorithm designed to identify dogs in a picture, it can only match a picture of a dog it has already been programmed with. However, an AI designed to perform the same task will compare the pictures with what it has been trained with and attempt to infer if a dog is present based on how closely it can match the images in its database. The process of adding known dog images to the AI's database is known as training. Now, there's a very important point. AIs don't have an innate understanding of what a dog is. They must be trained, usually with thousands to millions of samples, for it to stand a chance of accurately inferring if there is a dog in the picture. By the way, this is how ChatGPT, Siri, and Google Assistant all work, but with words rather than images. It looks at what you've typed or spoken and compares that to its database to infer what you are asking for. Then it searches for what it thinks you want and returns it to you, whether that be a sports score, playing a song, or compiling data into your latest term paper. With that in mind, let's look at the recent case, Thaler versus Perlmutter. This case starts with a man, a computer, and a piece of art. Plaintiff Stephen Thaler owns a computer system he calls Creativity Machine, which he claims generated a piece of visual art of its own accord. He sought to register the work for a copyright, listing the computer system as the author and explaining that the copyright should transfer to him as the owner of the machine. The important part of Mr. Thaler's claim is not that he wants a copyright for the art, but that he wanted the computer to be listed as the author. I find this a very dubious claim, since he clearly wants the copyright for himself, and I'm not the only one suspicious of Mr. Thaler's copyright application. The Copyright Office denied the application on the grounds that the work lacked human authorship, a prerequisite for a valid copyright to issue, in the view of the Register of Copyrights. Shira Perlmutter is the Register of Copyrights and Director of the United States Copyright Office. She is the one who ultimately denied Mr. Thaler's application for one simple reason. Listing the computer system Creativity Machine as the author would mean there was no human authorship, thereby making the application invalid. This, to me, is the crux of the matter. Do computer systems have property rights? To properly analyze this question, we have to understand what property is. Now, James Madison wrote an essay on this topic for the National Gazette back in March of 1792. This term, in its particular application means that dominion which one man claims and exercises over the external things of the world in exclusion of every other individual. In its larger and juster meaning, it embraces everything to which a man may attach a value and have a right, and which leaves to everyone else the like advantage. Property is that which someone holds dominion over. Mr. Madison specifically refers to a man here, but I want to discuss that later in this episode. So can a computer system hold dominion and exercise control over external things? I suppose in some cases, yes, but in the case of a piece of art, no. Even if Creativity Machine had the ability to interact with external things, it cannot hold dominion over them since it is owned by Mr. Thaler, which brings us to the question of free will. Back to Mr. Madison's essay. He has an equal property in the free use of his faculties and the free choice of the objects on which to employ them. See, Creativity Machine did not have the free use of its faculties. It was programmed to make visual art. It did not have a free choice of what to create. It was instructed to create a picture. So by all aspects of Mr. Madison's words, the art in question was not the property of Creativity Machine, rather it was the property of Mr. Thaler. This is confirmed by Mr. Thaler's own application for copyright, since he claimed the copyright should transfer to him as the owner of the machine. Next, we need to look at the question of copyright. In Article 1, Section 8, Clause 8 of the Constitution, Congress is delegated the power to promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. Congress can make laws granting authors exclusive right to their writings. Is Creativity Machine an author? Copyright law, Title 17 of the United States Code, does not define the word author, so let's look at a couple of other sources. First, from the Webster's 1828 dictionary, we see author means one who produces, creates, or brings into being. Creativity Machine did produce the art. Does that make it the author? If an author is one who produces, then we need to look at the definition of one in this context. Again, from Webster's 1828 dictionary. One is used indefinitely for any person. Now, today's Merriam-Webster online dictionary defines one as used as a third-person substitute for a first-person pronoun. Since one in this context is a pronoun used for a person, Creativity Machine is not an author because it is not a person. The court came to a similar conclusion, although by a much longer method. The 1976 Act's authorship requirement as presumptively being human rests on centuries of subtle understanding. The blurring of the lines between man and machine-made product will most definitely lead to future confusion. Undoubtedly, we are approaching new frontiers in copyright as artists put AI in their toolbox to be used in the generation of new visual and other artistic works. The increased attenuation of human creativity for the actual generation of the final work will prompt challenging questions regarding how much human input is necessary to qualify the user of an AI system as an author of a generated work, the scope of the protections obtained over the resultant image, and how to assess the originality of AI-generated works where the systems may have been trained on unknown pre-existing works, how copyright might best be used to incentivize creative works involving AI, and more. However, there does appear to be some questionable aspects to Mr. Thaler's claim. This case, however, is not nearly so complex. While plaintiff attempts to transform the issue presented here by asserting new facts that he provided instructions and directed his AI to create the work, that the AI is entirely controlled by him, and that the AI only operates at his discretion, implying that he played a controlling role in generating the work. These statements directly contradict the administrative record. Here, plaintiff informed the register that the work was created autonomously by machine, and that his claim to the copyright was only based on the fact of his ownership of the machine. It should be obvious to everyone that we are heading to a brave new world, one where machines will act more and more autonomously, thereby decreasing human involvement. While this will be a tremendous boon to productivity, it also raises serious questions. This case involved the question of authorship and whether a computer system had the right to own and control its creations. Today, in this court, in this case, the answer is no. This case, however, does bring to light a potential issue. What happens if one day a court decides that an author does not need to be human? Could an AI own, as property, the copyright for more than just a work of art? Could a machine hold a patent for a drug or vaccine? Could an AI develop and therefore own a DNA sequence? Would it then own whatever the sequence is, be it for a virus, cattle, or even a human? Congress has the power to protect the works of authors and inventors. As we enter this brave new world, perhaps we should make sure our employees in that body protect we the people by defining what an author is in the law. And that really is the question, the definition of author. Now, back in 1976, the last time the Copyright Act was updated, author was simple. It was a person. Machines could not author, but as artificial intelligence grows in its power, its speed, and its capability, as more and more people depend on AIs to help them in their work, at what point does author transfer from the human initiator to the computer completer? That's not something we should leave up to courts. That's something we should have done through our employees, our representatives in Congress. So while this case I found interesting because, one, I like the idea of AIs, I like computers, I like gadgets, and I find them interesting. But more importantly, that interesting question of author. Understanding what the word author means was important to understanding this case. If we don't know what words mean, how do we come to the right conclusions? That's why I focus so much on what words mean and going back to the original language to understand what's being asked. Now, if you have any questions about this case, about this episode, please go to the website, constitutionstudy.com, leave a comment, or find me on social media. I'm on several of them, Rumble, YouTube, Getter, Gab, Locals, Truth. I'm trying out a bunch of different social media to see what kind of engagement I get, and I'm always looking for comments. More importantly, if you have something you would like me to cover, if you have a question you'd like to ask or a topic you think I should cover here, well, please go to the website, click the Ask a Question button, and ask. I'll answer your questions as best I can. And as far as topics for this program, what's the worst thing that can happen? I say no. I want to make sure I'm answering the questions and covering the topics that you are interested in. So I love that type of feedback. I hope you enjoyed as well, and I hope you'll come back here and join us next time for the Constitution Study.
Love your neighbors and have a few good friends.